But right now, I'd like to introduce Matthew Vella. Matthew represents employers with respect to all aspects of labor and employment law, including union avoidance, wrongful dismissals, employment contracts, wrongful workplace policies, human rights, and WSIB issues. He's an experienced advocate. He has argued at all levels of Superior Court, as well as at the Ontario Labour Relations Board, the Workplace Safety and Insurance Appeals Tribunal, the Human Rights Tribunal of Ontario, and in labor tribunals or labor arbitration. So thanks very much, Matthew, and I look forward to hearing the tips and what's going on right now.
Wonderful. Thank you. Thank you very much. Well, welcome everybody. Thanks for joining my presentation here today. What we've tried to do is think of new topics in employment law based on COVID-19 and obviously the situation that we're all going through. And so what I'm going to do actually is I'm going to talk about, there's me, don't need that. What we're going to do is we're going to talk about two old topics that I'm sure everyone here has heard about already, because these two old topics have now merged into what we're seeing as a trending new hot topic. So we're going to talk about temporary layoffs, the infectious disease emergency leave, IDEL regulations, and return to work issues, which is something I assume everyone has already experienced to some degree or another. We're then going to talk about human rights and accommodations during the pandemic. But the reason that these two subjects have been selected, again, is that they are now being merged into a current trend and a current trending problem that we're seeing in employment law. So we'll start by talking about temporary layoffs, where we're at with those. So always important to remember that a layoff occurs where a worker earns less than half of their regular wages. So, often people think of a layoff as occurring when the employee is handed a letter saying, we're sorry, we don't have enough work for you. You're going to be off for a period of time. We'll call you back on X date, or we'll call you back when sufficient work becomes available. That's your traditional layoff. But during the pandemic, during COVID, a lot of people have been cutting wages or cutting hours. Hey, we only have work for you 2 days a week, or, we want to reduce your salary. We're going to reduce your hours. Those can also be layoffs, whether you're actually putting the person out of work or not. And so once you get to that 50% threshold, it's statutorily deemed to be a layoff. And so you may have people working for you right now who are at work today, but who are actually on layoff if they're earning half of what they used to. In the past, layoffs were always a contentious subject because the Employment Standards Act says that you can lay an employee off for a certain period of time. Common law tends to say that you can't. There's been some push and pull between the statute and the common law. But what an employee side lawyer will say is that in the absence of a written agreement, an employee will claim constructive dismissal for being put on layoff, for having a salary reduction or their hours reduced. And as you know, constructive dismissal is an allegation that, you've altered the terms of my employment, you've reduced my wages. I'm going to take the position that I've been effectively fired. I'm going to file a Ministry of Labor claim, or I'm going to sue you for wrongful dismissal. So the other issue with temporary layoffs, of course, is that even if you're within the statute and the employee is not claiming a constructive dismissal, there are timeframes at which point the employee is going to be able to say, I've been fired because I've been off for too long. Right now, none of that really exists, because what the Ford government has done is given a blanket protection to all employers in the province with the OREGs that have been amended under the Employment Standards Act to create the infectious disease emergency leave. So the IDEL regulation effectively allows all of the things that I just talked about to happen without an employee claiming constructive dismissal. So the employer can lay off, reduce hours, which effectively reduces wages, without getting the regular claim for, oh, sorry, that change is too much. I've been laid off. I would like my termination and severance pay, or more than that, depending on who you're dealing with. So this is the regulation, or a summary of the regulation, 228.20, which is the IDEL regulation. It's important to note a few things here. All of these regulations apply to non-unionized employees. So to those of you who are unionized, you have to follow your collective agreements. Your collective agreements will have timelines in them for what a layoff can and can't be. But for non-union, the IDEL regulation is here protecting you. So this says that a non-unionized employee whose employer has temporarily reduced or eliminated their hours of work for reasons related to COVID-19, okay, I've underlined that because this is what we're going to talk about later, is deemed to be on a job-protected emergency infectious disease leave. So if you have an employee right now who's at home and isn't working, that employee is actually not on layoff. They might have been given a letter back in April saying, hey, we're putting you on layoff, but they're now deemed to be on this leave, not on layoff. Second bullet point, the non-unionized employee is not considered to be laid off by the employer if the employer temporarily reduces or eliminates hours of work. So this is the non-traditional layoff where the employee is still working, but either has had their salary reduced or is only working 2 days a week or whatever that may be. We did see a lot of this in COVID where employers tried to keep people, employed as much as they could, but it was going to be reduced. IDEL protects that as well. So if hours or wages are temporarily reduced, if the person's on layoff, if the amount of days the person works are reduced, all of this is covered by this regulation, which says this is not a layoff. And so this effectively stops the constructive dismissal arguments. And, when we went into COVID in March and April, we expected to see a massive slew of constructive dismissal claims as, thousands and thousands of people, particularly in the hospitality, tourism, and travel industries, were laid off. They're being protected by this regulation. So one thing to note about the IDEL regulation, though, is that it is set to expire January 2nd. And it is going to, if it does expire, if it's not extended, then we are back into the traditional ESA rules for layoffs. And that's when employees could start to file constructive dismissal claims, Ministry of Labor claims, things like that. So, cognizant January 2nd is not very far away from us right now. But even with the IDEL in place, we knew that employment lawyers were going to try to find a way around it. And we didn't see a lot of an uptick in ministry claims and lawsuits throughout the pandemic until recently. And now we're starting to see a real uptick in claims from employees who have been off. We're seeing them in virtually every sector that has employees on layoff. So I am seeing it in manufacturing, in auto dealerships, in all kinds of different places. And so this is why we're going to talk about the second topic. What they're doing is, if you remember the previous slide said, you can reduce a person's wages and they're not on layoff. You can lay a person off and they're still covered. You can reduce their hours of work. The IDEL regulation will protect you. But every one of those protections is by reason of COVID-19. And so the reduction in hours, the reduction in pay, the temporary layoff has to be for reasons relating to COVID-19. So employment lawyers thinking this through, my client wants to make a claim. How do I make a claim? IDEL's blocking me. We'll say that they weren't laid off by reasons of COVID-19. We'll say that their salary wasn't reduced for reasons related to COVID-19. And where they've turned is to the Human Rights Code. So what we're starting to see and see a lot more of, even just in the last 2 or 3 weeks, is demand letters and claims coming through that say, we recognize that our client is on layoff. We recognize that IDEL exists, but he's not on layoff, or she's not on layoff because of COVID. He's on layoff because he's 60 years old and you don't like old people. Or he's on layoff because he filed a harassment complaint a year ago and you're retaliating against him. And so we're starting to see the nexus between the Human Rights Code and the Employment Standards Act grow as they continue to try to use it to get around the IDEL. The other thing that we're seeing is employees putting forward lots of accommodation requests, sometimes very novel, unique accommodation requests, and then saying, well, the employer failed to accommodate, so I can't come to work, and it's your fault that I can't come to work, so now I would like my termination and severance pay. So again, people starting to get a little bit more unique in the way that they attempt to assert claims. The other thing that we're seeing as employers have started recalling, and we saw a lot of this in August and September, is employees refusing to return to work and demanding severance packages and alleging failure to accommodate. So the way that dance tends to go is employer sends the employee an email saying, hey, work's picking back up again, come back on Monday. Employee sends email back saying, sure, I'd love to come back on Monday, but I have 5 conditions for my return of work. You're going to pay for a taxi every day so I don't have to take public transportation, and I'll never show up to work unless every single person in the workplace is wearing a mask. And if you have more than 30% of the people in the workplace, I'm too scared to show up. Employer says that those are too many restrictions, don't show up to work. Employee says, see, okay, failure to accommodate. And again, we get the demand letter. So I kind of jumped the gun on that, but this is the kind of thing that we're starting to see more of, right? We saw a lot of this in the early days of the pandemic as well for employers who stayed open. There was a long period of time throughout March, perhaps to May, where companies had made the decision, if they could, to stay open, and employees were not happy about that. So we had work refusals. Back then, we were dealing with the Ministry of Labor a lot on people saying, it's not safe to come back to work. My employer is not sufficiently keeping me safe at work. I'm refusing to work because it's not safe due to COVID. The Ministry of Labor took a really hard line on work refusals, particularly in April and May. And the ministry was very favorable to employers as long as the employers were safe. And we started getting decisions very quickly that said, general fears of COVID are not sufficient grounds for a work refusal under the Occupational Health and Safety Act, that the employee doesn't get to dictate what is and isn't a safe workplace as long as the employer is taking proper measures. They're fine. So employees then started, for legitimate reasons often, but started putting forward different accommodation requests. So I've listed here a few of them that I saw that I thought were particularly unique. People saying, I can't take public transit because it's not safe. So if you want me to come to work, then you're going to pay for me to take an Uber every day or a taxi every day. That was one of the ones we saw. The next bullet point is interesting because you see it on both sides. And I've had multiple workplaces where this one came up, where one employee says, I have asthma and wearing a mask recirculates the air into my face and agitates my asthma. So you can't make me wear a mask all day. And then you have another employee in the same workplace that says, I'm extremely high risk. I have a heart condition or I'm immune compromised. I won't attend the workplace unless everybody in the workplace wears a mask. So, I mean, what employers tended to do was for the person saying that they couldn't wear a mask was to have them work from home. That's not possible in every job classification. Obviously, it's easier if you're in an office setting, and I'm working from home right now. So if I refuse to wear a mask, it doesn't really bother anyone. I think if I was wearing a mask, this presentation would be a little bit muffled. But in the situations that I faced were fairly simple because we simply kept those two employees apart by having them either rotate working from home or having the employee who wouldn't wear a mask work from home. But there are always considerations and concerns, and the employers are saying, well, maybe this employee is just refusing to wear a mask so that he can always work from home, right? There are obviously the accommodation requests with respect to childcare. That's still a big one for people. I know, my son goes to school 2 hours a week, right? Thursdays and Fridays. Lots of people have had to come up with alternate arrangements for childcare. There are daycares that open and then they close because they got a case. There are schools that open and close. There are teachers who have to self-quarantine all the time. So the childcare issue is still really a live one, and it's something I'm sure all of you in HR have been dealing with for the last 8 or 9 months already. But worth putting on the screen for that. So then the next one is the generalized anxiety about COVID. That's an interesting one because we took a really hard line against that position early on in the pandemic and said, your general fears of COVID are not sufficient for a work refusal. But what people have started doing now is getting doctor's notes saying, well, my patient has an anxiety disorder because he or she's too scared of coming to work. And once it gets to that level, then it's obviously a mental health issue that needs to be addressed pursuant to the code and the accommodations. So, for all of these situations, it's extremely important that the request be handled properly and in accordance with the policies that you have in place or hopefully have in place. And where we've seen companies slipping up during the pandemic is making blanket rules and then applying them to everyone. So, we have a rule that you must be in the office 30% of the time, right? Or we have a rule that everyone must wear a mask, right? Perfectly fine rule, perfectly justifiable under health and safety laws. But what we've seen people get in trouble for is that when an individual comes forward with an accommodation request, that policy that's been enacted during COVID is just applied forcefully to everyone, right? And that's not technically proper pursuant to the Human Rights Code, right? So where people slip up with the Human Rights Code is what's called the procedural duty to accommodate. And the procedural duty to accommodate is the duty to assess each individual accommodation request and each individual circumstance based on the evidence that's available and based on sufficient evidence, and for the employer to turn their mind to what accommodations could be made. And so it may well be that whatever the employee is asking for cannot be accommodated. It may well be that whatever the employee is asking for is not safe and you're not willing to accommodate it. But the failure to assess the situation for each individual employee is where liability will ground itself and where an employment lawyer will come after you, again, taking the position that your failure to accommodate the employee means that the employee can never come back to work, and has effectively been dismissed, and that therefore termination and severance pay should apply. So it's important, and I know it can be frustrating, particularly if you're getting a lot of these kinds of requests, and they're sort of ever changing. But it's important that each one be assessed and that informed decisions are made. Informed decisions require proper documentation. So the employee saying, "I don't feel safe, I'm not coming in," isn't good enough. That employee needs to provide reasons as to why they can't come in, or medical documentation as to why they can't come in. And you need that as an employer, because if you're going to have to defend a decision, we've had employers who have taken the position that the employee has abandoned their job, and that the employee's refusal to return was job abandonment. And that's a feasible position, again, if the homework has been done to make sure that the employer has sufficient evidence, has turned their mind to the situation and assessed it, right? So, that's where, again, the Human Rights Code is being used to get around the IDEAL regulations. And what we're really seeing right now, again, more so in the last 3 to 4 weeks, is employees who have been off for a long time, and either they're fed up and they're ready to make a claim because they thought they were going to get recalled in the summer and they didn't. And then maybe they thought they were going to get, or maybe they did get recalled for a little bit in September when everybody thought that things were going well. And then, things turned around again. So we've got those employees who are just done with the situation and are looking to get their severance pay. And then you have the other side of the coin, which is employees who just don't want to come back and will try to find a reason to not come back, but to be able to garner termination and severance pay. So, compliance with the Human Rights Code and compliance, with the optics of the Human Rights Code, and being able to show a record of accommodation discussions, of accommodation requests, information requests, and things like that is important, because we're seeing more and more demand letters that say, well, we recognize that because of the infectious disease emergency leave provisions, you had the right to lay my client off, or you had the right to do this when you did it, but now that's not the case. Now the case is you're discriminating against my client. She told you that, due to childcare, she wasn't able to meet the requirements of the job. You didn't do a proper individual assessment of her circumstances or what positions could be available for her that would meet her needs. And therefore, you've discriminated against her. We're taking the position that she's been fired, that this has nothing to do with COVID-19 now, and it has nothing to do with the IDEAL regulations now. So, we want our money. And so it's important to make sure that right now you're really, dotting your I's and crossing your T's. I think the last thing that I'll say, because I'm running out of time, is that it's also a good time to make sure that your policies are compliant, are updated, and are somewhat flexible for accommodation requests, because the starting point of any accommodation should be the employer's policies with respect to accommodations in the workplace that should guide the human resources decisions, and should guide the company's requests for information and actions. And if those policies are even 2 or 3 years old, they are probably too far outdated based on the new normal, right? I mean, everything now is different than it was 2 years ago or even 1 year ago. So it's important to make sure that you're taking a look at those things. So